Good morning and good afternoon to you both. Thank you very much for your helpful notes. First of all, I think we better call the case on.
Thank you, Your Honour. Good afternoon, all. This hearing is in the matter of DEC 001-2025 and is being held by way of video conference before His Excellency Justice Michael Black KC, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the Registry in Dubai on the judge's instructions. The claimant is represented by El Tamimi and Company. Lead counsel is Mr. David Holloway. The first defendant is represented by Quinn Emanuel Urquhart and Sullivan. Lead counsel is Mr. George McPherson. Thank you, Your Honour.
Thank you. So let me tell you where I'm at. You can then try and dissuade me if you don't like what you hear. So far as the claimant is concerned, I am going to adjourn all costs argument until the hearing of the hand down, which will follow the circulation of the draft judgment and any corrections. So I am accepting the submission by the first respondent on that. For the avoidance of doubt, that would include the disposal of the sums currently standing in court. However, I do think that the proceedings should be made public, and they will be made public, and all the previous decisions will be made public on the hand down of my final decision. And I will order that all documents supplied to FDI should also be disclosed to the claimant. It seems to me to be elementary fairness in relation to that. So far as the first respondent submissions are concerned, I think it's premature to apply for permission to appeal at this stage, and I'm minded to extend time for applying permission to appeal within an appeal notice to be filed 21 days after the date of the hand down. As a matter of information, just so it's not thought that I have crafted the judgment to meet this point, I have already considered the grasping the nettle point, and in the draft judgment and in the final judgment have stated that I find it inappropriate to do so without proper disclosure, background information, and where the final decision is to be taken by the Hong Kong court under Hong Kong law, which may or may not, in material respects, be identical to English law. So those are my necessarily preliminary views. If you would now like to address me on those, first of all, Mr. Holloway, and see whether you either agree or disagree with what I've said.
I agree with Your Excellency on obviously the decision that you made, and also on the permission to appeal point. I mean, even from Mr. McPherson's own skeleton, one can see that it is intended that a further grant of appeal be drafted after the decision is handed down. And also there's quite a bit of speculation in what he has said about what your reasons may or may not have been, and why he may or may not want to appeal them. So we would submit that is the appropriate way forward. I mean, what one can't have in my submission, this whole thing has been kitchen sink approach, spaghetti on the wall approach. We can't have something like that going up to the Court of Appeal. And then without refinement, I think one needs sort of fine consideration of points that actually have any merit or not. And I think it's, this hearing was listed, I believe, because the respondent envisages that they might urgently want to do something. But if they're going to craft,
well, I know I directed that the hearing be listed. I thought it was only appropriate that I hear the parties, given that I will have I've made an order so that we can see where we stand. I mean, at the moment, I'm 150 paragraphs into my judgment, which is probably about halfway through.
And in terms of the grasping the nettle point, we agree with what you actually just said. I mean, that's a new point, and in my submission, a bad point, given the fact that this is Hong Kong law, that you are deciding the arrangements between parties like FDT in the absence of any evidence or disclosure from FDT under Hong Kong law. And then that obviously is something that can't be finally determined by this court. It would be better finally determined with full submissions on law and full disclosure of witness evidence from the relevant parties, which will happen at trial. Then, in terms of the public hearing, obviously that is our position. Whilst the ex-party proceedings are normally held in private, there is no rule that would say that even the return date would normally be held in private. But now that we've gone beyond that, there's no reason why for any further privacy or secrecy. And just one point leading on from that is in relation to the documents which Your Excellency touched upon. You're seeing from our skeleton that we would like to revisit the narrow collateral use of documents that is permitted in the order. Perhaps I could address you on that briefly if.
Well, I'm not going to make an order on that today. I mean, that's something that we'll have to stand over to the hand down. I mean, what I'd envisaged is a full day set aside once the hand down is given, which I hope will be in early September, where we can deal with all these matters. But I don't think it's appropriate that we deal with everything when neither side has seen my full reasoning and the judgment.
Then I guess then on costs, I mean, we would seek to persuade you to make an order in principle today. Your Excellency, they came, they saw, they lost, they pay. It's a basic rule in our system. And Mr. McPherson, the Dos Santos case doesn't help him. This is a freezing order. One can see that.
Yes, I mean, no. I mean, you're starting a goal up, clearly, but I think it would be inappropriate for me to make an order today without hearing full argument on it.
And well, I mean, we do say that we've had to invest quite heavily to get to this point. Not only have we had to invest our own costs, we've had to pay in a premium to cover their costs. And we do say that given that we've prevailed, there really is no basis on which that security for costs should be retained by the court. And also, we shouldn't be kept out of our money any longer than we've already been. So we would be trying to persuade.
No, I understand the position. Obviously, I have thought about those arguments, but I still think that given that we're not too far away from when the final order will be made, that it's appropriate just to wait a little longer. But it is clear that you have prevailed. And clearly the respondent will have to tailor its arguments accordingly.
And then, well, I take that on board, Your Excellency. Thank you. I guess then we're left with, if we're not dealing with these matters today, the format in which the further application will be made. I mean, we will be seeking, for example, to revisit the collateral use exception,
Sure, I see that.
We'll be looking to perhaps revisit the business use exception. We want to address you on various matters.
Well, those are all matters. I mean, what I envisage will happen is hopefully within a week of when I get back, which will be around the 21st or so of August, you will get a draft judgment, and we can then fix a date and also fix a timetable for the submission of the parties' applications.
Then the only outstanding issue we had was compliance with the original order, Your Excellency. We've addressed that in the skeleton. I can be very brief about it, but it's, I mean, if I could probably best turn you to what you previously said about this, which is just 1-2 paragraphs of a previous judgment.
Let me have a look at that. I mean, you can obviously gather my inclination is to put everything back.
Yes.
But with the exception that I do think that it's basic fairness that you should have access to what FTI had access to, and I'm willing to order that.
Well, just if I could perhaps try to push you a little further, Your Excellency, but
okay.
Just ask you to look at page 1174.
Bear with me while I get the big file up. One 1174, okay.
And then it's really paragraph 61, 62, and really 63.
Yes, I see that. Let me just read that. Yes, I mean, some of the redactions have been removed from these documents, haven't they?
Yes, some of the bank statement documents have been bank statements, but actually the central point is what the order required them to do is give us the beginning, middle, and the end, if we use the language of the hearing, where the money's left and where they ended up. And an audit trail, as you said in paragraph 63. We had to take them to court. We had to make separate applications, even to get the bank statements. And what we're wrestling with is the raw data of those bank statements. We've had to draw the conclusions from it. FTI, as you know, have got a little bit more information. They've got these bank payment records, but only some of them. What we say is that it's not enough just to get this raw bank data. Mr. Britton should be complying with the original order, which is to swear an affidavit telling us where the monies have ended up and backing it up with the documents that show that, rather than just making us fight for the bank statements themselves and get Kroll to have to analyse the inadequacies of it all.
Yes, I think. I mean, I think what I should do, as I say, is order that everything that FTI has access to, you get access to immediately, and I think it's something that you should put in a specific application for.
Well, we'll do that if we must, Your Excellency. However, it is an application that they comply with.
I think you should for 2 reasons. First of all, that I would like it. I would like some definition, some more definition, so that if I'm going to make an order, it is absolutely clear. And secondly, and associated with that, that unless it is possible for the court to make an order which is very clear in its terms, you won't get very far in the future if you have to apply for committal for contempt.
Yes. Point taken, Your Excellency. Then we'll take that away. I had one final point to make, which is in relation to paragraphs 25 and 26 of Mr. Macpherson's skeleton.
Let me have a look at that. It's 25 and 26. Yes, just let me read that.
Thank you.
Yes.
I'm slightly confused by that paragraph because I'm looking at your reasons.
Well, yes, I know. Let me tell you this, and if I can be absolutely frank with you, I have not completed the part of the full judgment that deals with full and frank disclosure. What I'm happy with is that if I do ultimately decide that there has been any lack of full and frank disclosure, I'm happy that it would not justify discharge of the injunction. It doesn't mean that I'm 100% with you on that. And I think it's a fair point made at 25 and 26. That if I were to find that there had been some, but non-fatal as it were, failure, that could have an effect on the issues of costs. So I think 25 and 26 are fair submissions.
Very well, and thank you for that, Your Excellency. I'll leave it at that for now. Thank you.
Okay, thank you very much indeed. Mr. Macpherson.
Thank you, Your Excellency. So I'll take first the permission to appeal application. I obviously hear what Your Excellency says about that. I would just say this. I mean, clearly we're before you today, and there is an element of urgency necessarily in a case such as this, where, as has always been our intention, is the need to, on our side, to get this order discharged as soon as possible. And any delay in that process is something we resist. I entirely accept Your Excellency's point that until your full reasons are published, it is tempting to say that any permission application should await those reasons so it can be fully formed. But on the other hand, what I was going to be advancing to you this morning is a limited argument on the basis of the proprietary case. Your Excellency has formed a view on that, and that indeed is the basis on which you found that the injunction should continue. And even on the basis of those limited reasons, we would say that it's a sufficient, there's a sufficient reasoning there for us to make a permission to appeal application. And all I would say is that the submission we would wish to make is simply that there is a real prospect of persuading a different court that this is a point of construction that a court can grapple with. And once that is accepted, the contractual argument is a relatively narrow one. But because, as I've said in my skeleton, it comes down to what the ESA says, and in particular what clause 6 says, that is a narrow point. Now, if Your Excellency is against me on that, as you've indicated, then then you've effectively said so already. I'm not sure what point it is going to serve to have a further hearing several weeks hence, where we make those same arguments in the expectation that the same result will follow. And in the interim, we won't have an opportunity then to prepare an application for permission to appeal to the Court of Appeal.
Well, I mean, first of all, of course, one appeals against orders which I accept rather than judgments. So yes, strictly speaking, I suppose that since the current order is the injunction continues, you could certainly do that. There is quite a lengthy section of the draft judgment dealing with this point, and indeed dealing with what I have considered to be the anomalies in the agreements when you read them together as a suite of documents. I think if your position now, without seeing that, is just we think you're wrong on the arguments that you put forward, I would refuse permission to appeal. But I'm not refusing permission to appeal. You will have a better prospect to get permission to appeal when you've actually seen the reasoning, I think. But the reasoning, if I may say so, is more extensive possibly than the arguments that were they flow from the arguments and they find their basis in the arguments, but they build upon them. And I think you want to see the reasoning before you make the application for permission to appeal. But I understand everything you said, and I'm not stopping you.
You're not stopping me from making the application now, or?
Well, you can make the application now, but my present intention is to adjourn it. And you can try to persuade me not to adjourn it, but I think you've got a bit of an uphill struggle. If, in some ways, if in fairness to you, I think there is a balance between timing and the opportunity to mount a full argument, and I think the opportunity to mount a full and reasoned argument probably outweighs the additional prejudice of having me refuse permission today, and whereas you're having a better chance in the future.
Yes, I accept all of that, and it's helpful to have it's helpful to have that indication as to the further reasons. I suppose in the position that we find ourselves, it's somewhat invidious, because clearly whenever you're before a first instance judge who has made a decision and clearly thought very carefully about it, the frequent consequences is that a view has been formed, and therefore the chances of shifting the judge from that view in a few weeks hence will be difficult.
Yes, of course. I mean, it's always in a sense one always uses the word invidious. I don't mind, and I don't mind being told I'm wrong, and I'm happy to recognise that there are other views. So I'm not closing the door on permission to appeal in any way.
Thank you. Thank you, Your Excellency. In that case, I mean, you have my written submissions,
yes.
And I've dealt with. If I can deal with it very briefly, that I mean, the first point is clearly the point you have, which is that this is a simple point of construction. And then once that is accepted, or if that is accepted, it is simply, we say, a question of construing clause 6, and notwithstanding, as you've indicated, that you have taken a different view, that it does encompass broader considerations than clause 6. We do say that there is a real prospect of a different court forming the view that really it is all about clause 6 and the overriding language in clause 6, and whether a trust in favour of the claimant can be spelt out in the light of that clause. That really is the essential point, which is why we say it's a short point of construction, and one on which we should know where we stand as soon as possible, and that there's a real prospect, as I say, of persuading a different court that there is merit in our position. But that's really that's the way we put it, and that's the only way we put it for the purposes of today's application, and that is why we would invite you to determine that application today, notwithstanding everything you've already said.
Thank you very much indeed. That's very helpful and very nicely put. On this occasion, I think I am settled in my view. So look, I'm going to ask perhaps Mr. Holloway if he could put together a minute of the order for the court to issue. So the first thing is clearly that the two current injunctions will remain in place until further order. All other issues, costs, and any consequential applications, including applications for permission to appeal, will be adjourned to a date to be fixed when the draft judgment is handed down. Draft judgment is circulated for the parties' comments on typographical errors. Those applications will be made at the hand-down hearing of the judgment, with an estimated length of hearing that day of 1 day.
Thank you, Rexy. I'll draw that up. Just to clarify on the public nature of the, is that to be held over until hand-on, or is that an order that you want to make today?
The proceedings, no, I think I'll make it at the time of hand down. But the other order that should be included in today's order is that the first respondent should disclose forthwith all documents that have been supplied to FTI that have not been supplied to the claimant.
Your Excellency, forgive me. Can
Yes.
I make 2 points, because I think
Yes,
I
of
made
course.
my submissions on PTA and then
Yes, no,
haven't said anything
I
else.
didn't hear you on this. Yes, of course.
On 2 points on the public-private decision. Clearly, I've heard what you say about that and when that is going to be effective from the date of hand down. Just let me have a go at persuading you that it should remain private.
But let me just put a stumbling block in your way, if I may.
Yes.
Would that mean that my judgment could not be shown to the Hong Kong court? Because if it, That would seem rather odd. And then if it's shown to the Hong Kong court, what about the other parties to the Hong Kong litigation, FDT, Truecoin, and so on? So if it's shown to the Hong Kong court, it's public, and I can't see how it can't be shown to the Hong Kong court.
Yeah. Yes, I mean on judgment. I mean, I do recall having this experience before, where obviously judgments have a different status from what is said in the course of submissions and transcripts and so on, and that sometimes it is necessary to conduct quite a forensic editing exercise in respect of a judgment, whereby there is an opportunity to make submissions in relation to the content of the judgment and to say this or that part of it should not be disclosed. Now, I wouldn't want to prejudge that process at this point, because it will depend on what Your Excellency's judgment says. But I would want to reserve our position in that respect.
No, that's fair. That's fair. Well, that's why it will be circulated in a normal confidential way, and that's why it's probably best that we decide the issue of confidentiality at the hand-down hearing.
Okay, so at least at this point, nothing is being decided today, which is going to render anything in these proceedings public, which up to this point has been private. That is the effect of...
I think you're right about that. I understand what you're saying, and I accept that, and I will decide whether the whole thing is public, whether just the final judgment, or whether parts of the final judgment or the previous judgment. We can decide all of that at the hand down, and you can make detailed submissions with reasons for that.
The other two further points, and I think that is all from me. The first point is just on permission to appeal. Can we have prospective permission, if that is indeed necessary, to apply to the Court of Appeal upon hand down of the judgment? Simply because we do want to reserve our position, and we do have a concern that we may be prejudiced on costs if we're in a position where we haven't yet had an opportunity to apply for permission to appeal, and yet costs arguments are effectively being made at the same time.
So what do you mean by prospective? So what are you contemplating?
So that upon the hand down, we could seek permission from the Court of Appeal in respect of the order as evidenced by the reasons, rather than first seeking permission from you, so that course was open to us.
Yes, I mean it's no look. I mean the way it would go is at the hand down. I would decide yes or no at that time. If you press me to, that's absolutely fine, because you'll have seen the judgment. You will have your reasons. You could go after the Court of Appeal an hour after that. I mean, I'm not sure that it's necessary to make any special order.
Yes, I think
you may succeed in getting permission from me. You never know. Don't be so pessimistic.
I'm being extremely pessimistic. I must admit. I don't know why, but I'm planning for a worst case scenario. Put it that way. What I think, what I was let me put it this way. I think what I was envisaging was that there might be a scenario where judgment is provided. There's obviously going to then be a window of time between us receiving the judgment and the hearing at which we make our permission to appeal application. And the purpose for this provision would be that in that window of time we could go to the Court of Appeal. rather than await the hearing before Your Excellency that followed the hand down. It was simply to preserve that entitlement.
Yeah, I don't think. Let me just get. I did actually. Well, again, just for your benefit, and it's even happening both yesterday and today. We are actually revising the rules on appeal, which would allow you to do precisely that in any event. But let me have a look at the existing rules, if you'll bear with me
Yes,
a second. I did look at them this morning in the context of our revisions. So where are they? Right, just as I say, bear with me momentarily. So, as the rule is presently drafted,
246, is it?
yeah, I'm just looking at that. It's mandatory that an application for permission to appeal must be made to the lower court. In fact, we will change that. That will be permissive, not mandatory. But I think as things stand, so you were entitled to apply today, 4461, to apply orally today. Or an appellant's notice. Let's just have a look at the Court of Appeal. I mean, if you want me to refuse permission completely, and then you can go off to the Court of Appeal at any time thereafter, that's fine. I mean, it seems a little unfair when you've not seen the judgment, and I may actually grant permission to appeal, which would probably strengthen your appeal if I'd granted permission. Hello, court considers the appeal. Can you go? I think the rule as presently drafted means you have to make a proper application to the lower court first. It does use the word must in 44.6.
I think that the concern, if I can put it, before I come back to you on whether I'm going to invite you to, in effect, hear and dismiss our PTA application today, I think the concern arises, it's really a question of timing, as I indicated. So as I understand it, the present plan is that you will hand down your judgment at some point later in August. The parties will have an opportunity to study it. There will then be a hearing at which consequential matters will be determined, one of which will be costs, another of which will be the adjourned permission to appeal application, so that both those applications will be heard at the same hearing. And there's not a scenario in which the permission to appeal application is going to precede the costs application.
No, but I mean, I mean, just putting my Court of Appeal hat on for a moment, if you went to the Court of Appeal before you had my reasoned judgment, I suspect the Court of Appeal would say, we'll wait until we see the reasoned judgment before we deal with permission. I think you'd be stuck with it. But just looking at the rules presently drafted, so 44.16 seems to be in mandatory terms, and then 44.9 says where the lower court refused permission, a further application for permission to appeal may be made to the appeal court. So you can't go to the Court of Appeal until I've refused permission or given
Right.
or given limited permission. So then.
Right. Sorry.
So then it seems to me, and then the Court of Appeal likely say, well, we'll wait and see the reasons before we decide. I think you end up in the same. I think you end up in the same place whether you like it or not.
Right.
Sorry, Mr. Holloway.
Yeah, so I'm so sorry, but it's plainly obvious what's going on here. I mean, you'll have seen from my skeleton that we will want our costs to be paid as a condition of any appeal, and what Mr. McFirst is trying to do is get the appeal up and running and not pay the costs. I just think we shouldn't really be indulging this too much.
I take the submission at face value rather than having an ulterior cost motive. This is, which I accept, an intrusive order into the business of Aria. It's necessarily made at an interim stage before a final decision on the merits. I have formed certain views. So no, I don't take such a cynical view as you do on the motivation of the application.
Your Excellency, again, let me have another go at formulating this. I think the issue is this: that we will get the judgment. There will then be a hearing a week or so hence, and what we're looking for, because you obviously rightly identified the point that the Court of Appeal might say if we went off tomorrow and said, well, all we've got is an 11-paragraph summary of future reasons, and that's not good enough. Let's await the reasons. But if we're in the position where we've got the fully reasoned judgment, but the consequentials hearing has not yet happened, then what's to stop us at that point with the judgment having been handed down in advance of the consequentials hearing, going off to the Court of Appeal, at which point they couldn't make that objection that there are no reasons. And I think that was my proposal, was that at that point, can we have, to the extent we need it, which I think we might, because if we haven't made the application,
I think the trigger for you to get to the Court of Appeal is a refusal of permission to appeal from me. You may ask me when you see the reasons to refuse permission to appeal in advance of the consequentials hearing. That's a matter for you, it seems to me. Once you see the reasons, I'm not shutting that out as a possibility. You may come back immediately and say, will you please refuse permission, so that we can go to the Court of Appeal. I'll take that. I'll take that on board if and when it comes. You may wish to have a bit more time. It's up to you. But I don't think I can do anything today.
Well, having canvassed this possibility at the outset, I think Your Excellency canvassed it, which is that we do invite you to determine it today. We've obviously made the application. You've given an indication, and that you determine it based on the submissions I've made. Which
well, I can, if you want me to, if you want me to deal with every potential ground of appeal, I will happily order today that permission to appeal is refused.
Yes. I mean, obviously, what we've done is we've put it on the narrow basis, the single ground of appeal, but that's the basis of my application, and we would invite you to determine that application today.
Okay. Well, in that case, we will include in this order that Mr. Holloway is going to produce a draft of, that permission to appeal is refused.
And the other point that arises out of that then, which was a point that I did raise in my skeleton, which was that then we have the the issue of, because that will then start time running, so that we do have the 21 days running from the date of hand down.
Yes.
So that we have that window of time in which to make our application to the Court of Appeal.
Let's just have a look. Yes, it obviously can't run from where the lower court makes no such direction within 21 days. Just looking at 4410, 21 days after the date of decision. It seems to me that you want to have the 21-day period after you've seen the reasons. So we will.
Yeah.
I mean, that's having your cake and eating it, isn't it? I mean, it's his own choice to say that you want to refuse permission. Then the clock runs from the decision if he wants to, as you gave him the opportunity.
I know it doesn't make a lot of sense to me because, frankly, because I might have granted permission.
Yes. So you pay your money, you take your choice. If he does it properly, then he makes a proper application before you, and the time runs from then. If he wants to shortcut it, then we shortcut it properly, and you follow the rules. You don't get to sort of game the system like that.
But I was willing to give the claimant to give the respondent 21 days from the date of the hand down within which to file its notice of appeal in any event. The only thing, I mean, I'm not sure it's gaming the system. The only thing that it seems to me that the respondent has achieved is it's denied itself the opportunity of getting permission from me. That's all. And that may have a cost impact. We'll have to see.
It gives them extra time to prepare.
It doesn't give them extra time because what I was proposing was that 21 days ran in any of it, that I would decide yes or no on the hand down, and 21 days to go to the Court of Appeal would run from. So they're getting no more than I was going to give them anyway. All they've lost to themselves is the opportunity that I might have given permission to appeal.
I misunderstood that, and I apologise. I'm sorry.
No.
Your Excellency,
when I put it that way, you're considering your position.
No, that I'm not going to revisit this now unless I receive a WhatsApp in the next 60 seconds. What I was going to say was there was one other point, which was this point about information and documents and so on.
Yes.
And you've obviously indicated that you're as currently and envisaged, the order will have a provision that FTI or first respondent provide documents supplied to FTI. Now there's no issue with that, but my instructions are that those documents have all the documents that have been provided to FTI have been supplied, and that they are actually in the trial bundle. So there isn't anything else
well, perhaps
out
that
there.
can be maybe that can, if that is the answer to the application, then those documents can be identified. And in that case, I think I should like an affidavit confirming that all of the documents that have been supplied to FTI have been supplied to the claimant, and that's to be sworn within 7 days.
Sorry, the position is all documents which FTI has relied upon.
No, that's different.
Provided.
I want all the documents that have been supplied to FTI to be supplied to the claimant.
Okay, well that's
you cannot have one set. You cannot have experts working on one set and not supplying those documents to the other side.
No, understood. Maybe this is in the drafting, but in that case, given that clarification, then I think we revert to the original proposal, which is that all documents supplied are provided rather than the affidavit. Is that I think that's the position.
Well, what you worried me slightly now with that suggestion. I think what we're going to have is the supply of all the documents that have been supplied to FTI and confirmation that those documents are complete by affidavit within 7 days.
Okay.
Anything else?
I don't think so. Let me just check.
Let me check as well.
No, nothing else, Your Excellency.
Okay, well, thank you. Well, I may or may not have the opportunity to review the order depending on whether I'm traveling and have access to email. It's unlikely, so I'm going to have to leave it with you both. And of course, I have absolute confidence in you to make sure that the order does reflect what I have stated today.
Wish you a nice holiday, Your Excellency.
Thank you very much indeed. I'm grateful. Okay. If there's nothing else, I'll wish you both a good day. Thank you very much.
Thank you. Good day.